Last study. Start. Sri Rastogi further submitted that, as a matter of fact, the subject suit itself is a frivolous one. The suit land belonged to the predecessors of the appellants, and it was acquired by the state and the compensation duly received by the appellants. The proceedings for enactment enhancement are also pending before the High Court. Stop. It is submitted that entertaining the application at the instance of a stranger for condonation of delay in filing an application for restoration of a frivolous suit is nothing else but a travesty of justice. Stop. It is submitted that for the same reasons, the judgment of the High Court is also not sustainable. Stop. Sri Sundaram, learned senior counsel appearing on behalf of the respondents, on the contrary, submitted that respondent number 1 has accrued a right in the lease on account of an agreement for sale dated 8th December 2009 entered into between it and the legal heirs of the original plaintiff. Stop. It is submitted that since respondents number 2 and 3 were not prosecuting the application for condonation of delay in filing the application for restoration of the subject suit, respondent number 1 was justified in filing such an application. Stop. It is submitted that in any case no interference is warranted in the concurrent orders of the trial court and the High Court. Stop. We find that the approach of the trial court in entertaining the application filed at the behest of respondent number 1 is totally unsustainable in law. Stop. The claim of respondent number 1 is on an unregistered agreement for sale dated 8 December 2009. Stop. We do not wish to comment anything upon the said agreement for sale inasmuch as the same may prejudice the rights of the parties. Stop. However, entertaining an application filed at the behest of a stranger for condonation of delay in filing an application for restoration of the subject suit is totally unsustainable in law. Stop. Admittedly, respondent number 1 has not even been impleaded in the subject suit. Stop. As such, the application filed at the behest of the stranger who is not a party to the proceedings is totally illegal. Stop. If the approach as adopted by the trial court is approved, any Tom, Dick, and Harry would be permitted to move an application for condonation of delay in filing an application for restoration of the suit, even if he is not a party to the subject suit. Apart from that, an application for condonation of delay in filing an application for restoration of the subject suit at the behest of the legal heirs of the original plaintiff is very much pending since 7th November 2019. Stop. It is difficult to understand as to what was the compelling necessity for the trial court to have entertained the application filed at the behest of respondent number 1 after a period of 2 years from the date of filing of the application by respondents number 2 and 3. The trial court could have very well decided the application filed by respondents number 2 and 3 on its own merits and in accordance with law. Stop. We do not appreciate the propriety in keeping the application filed by the legal heirs of the original plaintiff in 2019 pending and deciding the subsequent application filed by respondent number 1 in October 2021 within a period of 6 months. We do not wish to say anything more on it. Stop. Though it was urged by the appellants before the High Court that respondent number 1 was totally a stranger and the reasons given for condonation of delay did not constitute the sufficient cause, and though the judgments of this court were relied upon to contend as to why the application ought not to have been allowed by the trial court, the High Court has totally ignored the same. Stop. In light of the view taken by us, though it is not necessary for us to consider in detail as to whether the reasoning given by the trial court and the High Court as to whether respondent number 1 had made out a sufficient cause for condonation of delay is correct or not. We are of the prima facie view that the reasoning given by the trial court as well as the High Court for condoning such an inordinate delay will not come under the ambit of sufficient cause as has been delineated by this court in a catena of judgments. Stop.